In this frequently asked questions video, we're going to talk about what it means to be the petitioner and the respondent in a family law case, specifically in a divorce case. Now let's start with the basics. A petitioner is the person who petitions the court. They're the one who are filing the divorce petition with the court and getting the case started. The respondent is the one who responds to the petition. Now, the petitioner also has to pay the initial filing fees to start the case. And the petitioner is also required to serve the respondent with a copy of the petition and summons and any associated document with the next court date. This service can be done personal service, or the service can be done via substituted service if you get an order from the court saying that you can do that. Now, the question that arises most often is, what are the advantages and disadvantages of being the petitioner or being the respondent in a case? So essentially, what are the advantages or disadvantages of filing first? So from a purely court perspective, and from how a judge would look at the case, just having your name as a petitioner or having your name as a respondent is not an advantage or a disadvantage. There are really no actual advantages or disadvantages, although there are a lot of arguments and a lot of discussion about whether or not strategically in terms of the case there's an advantage. Some people feel that if you're the petitioner and you file the case first, you also get to present your evidence and testimony of witnesses at any hearings first. And there are some people who think that that might be a strategic opportunity or a strategic advantage over the respondent, in that the judge does hear your case, your side of the case, your theory of the case first, and that kind of stays in their mind right off the bat. There are some people who believe that it is advantageous to be the respondent and to go second and to be able to respond to the petitioner's case and present afterwards, after the petitioner does. So it really depends on how you look at it. I recommend that if you are trying to figure out what works best or what may be better for you, that you speak with an attorney who can go over what each means, what it might look like for your case, to be the petitioner or the respondent. But a lot of times it really just comes down, especially in divorce cases, as to who is ready to file, who feels that they can't wait any longer and they want to start the case. And oftentimes there are situations where you have to file very quickly. There might be some kind of risk or potential harm to you, and you need to file to be able to get court intervention or have the court involved. And oftentimes this might be if you have children or if they're assets or anything like that. So it is really a strategic in terms of your personal decision as to whether or not you want to file first or not. And if you have any questions or confusion about whether you should file or whether you should wait for the other person to file, I do recommend speaking with an attorney so that they can walk you through what that means and if there is any benefit or disadvantage to filing or to waiting to file. I hope this video was helpful, and we look forward to seeing you on our next frequently asked questions video.